Hello everyone, welcome back to BBA Simplified. I'm Dr. Vinky Sharma, and in today's marathon class, we begin with Unit 2, which covers some of the most important practical and widely used concepts of the Indian Contract Act, such as void contract, contingent contracts, quasi-contracts, indemnity, guarantee, bailment, lien, pledge, and contracts of agency. These are extremely important not only for your exams but also for real life business, banking, insurance, and managerial applications. So let's begin Unit 2, Special Contracts, explained in the most simplest and clearest way. Each of these topics that we had talked about, they form a separate section under the Indian Contract Act, and exam questions are usually directly asked from these headings. You will also see several real life examples, so the concept becomes easy to remember, starting with the void contracts. A void contract is a contract which is not enforceable by law, or a contract that becomes unforeseeable after the formation. According to section 2J, we say that a void contract is a contract which is not enforceable by law or a contract that becomes unforeseeable after the formation. So basically this means that 1, it was invalid from the beginning itself, or second could be that it was valid when made but later became void due to some event. For example, a contract with a minor is a void contract. Why? Because minor is not competent to contract. Similarly, an agreement without consideration is void, as it accepts in special cases. If a contract's performance becomes impossible, such as a person dying before singing performance, the contract again becomes void. So in short, we can understand that a void contract cannot be enforced in a court of law because there are no rights or no obligations on either of the parties. What are the various characteristics of void contract? So let's look at the main features here. These are commonly asked in the exams. The first one is that it should not be enforceable by law. There should be no legal enforceability. Neither party can sue or be sued. Then we say that there are no obligations. So since the contract is void, the parties do not have to perform anything. Therefore, there are no obligations. Next is can become void due to future events. Example, a contract depending on an event that becomes impossible, such as a sports match being cancelled due to government restrictions. And then the last one is that it arises because of legal deficiencies. Also, we talk about where we see that there are no compensation except in specific provisions. For example, under quasi-contract, compensations may still be granted. So here we understand that a void contract basically has no legal compliance even if the parties thought that they had formed a valid agreement. Another important question from examination viewpoint, differentiate between void and voidable contract. So let's understand that what is a void contract and what is a voidable contract and how do they differentiate. A void contract is invalid from the beginning or it becomes invalid. Neither party is bound here. No legal relationships are formed. It is caused by illegality, impossibility or lack of competency. For example, contract with a minor, right? What is voidable contract? We say that a voidable contract is wherein it is valid unless the aggrieved parties cancel it. Only one party is bound here, the other has the option to rescind. Usually it arises due to lack of free consent such as coercions, undue influence, fraud or misrepresentation. For example, a contract signed under the pressure. So the affected party may choose to void it. So in simple words, when we look at the difference, we say that a void agreement was always invalid, whereas voidable agreement was valid until someone cancelled it. So understanding this difference will help you greatly in solving the case-based question, right? Here, if we look at the components, we say that under void contract, there is no compensation involved. But in case of voidable, because one party cancels the contract, so damages may apply. In case of void contracts, there are no obligations on either of the party, but in case of voidable, only one party may cancel it. In case of void, we say that it is invalid from the beginning itself, but in voidable, it is valid until either of the party makes it avoided. Now we begin the next important part of Unit 2, that is contingent contracts. Let's first understand the meaning of contingent contracts. Section 31 of Indian Contract Act defines a contingent contract as a contract to do or not to do something, if some event collateral to such contract happen or does not happen. Or maybe in simple words, we can say that a contract that is dependent on the happening or non-happening of a future uncertain event. We understand that a contingent contract is a conditional contract. The promise becomes unforeseeable only if a future uncertain event occurs. For example, insurance contracts. Why do we take a life insurance? Because of the uncertainty. Only if a person would die in an accident or due to any of the health reasons, then only the insurance amount would be paid. So it is only payable if the accident happens. A agrees to pay B rupees 50,000 if B's house catches the fire, for example. Or maybe we can say that A agrees to transfer the property if B gets married next year. So these are the contracts which happens on some future event that may happen or may not happen. These contracts depend on the events that may or may not happen. So they are extremely important in businesses. Why? Because most corporate insurance and risk-based agreements, they function through the contingent contracts only. Now we look at some essentials of the contingent contract. For a contract to be considered contingent, it must satisfy certain essential conditions. The first condition is that event must be collateral to the contract. This means the event is external and not a part of the contract's main promise. For example, delivery of goods depending on a ship arriving safely, wherein a businessman says that I will only be able to deliver your product if the ship arrives safely. So we say that here the event is collateral. Next, we say that event must be uncertain. The entire contract depends on something that is not guaranteed to happen. For example, I will pay you if it rains tomorrow. Are you certain that whether the rain will happen or not? Not really. And then the third essential condition is that contract becomes enforceable only when event happen or does not happen, where we say that the parties cannot demand the performance until the event is decided. There are some other essentials also. For example, there is no control over the event. Neither party should have a control over the event. For example, if A says that I will pay B if A wishes, this is not a contingent contract. It is a void for uncertainty. So these essentials helps us distinguish the contingent contracts from ordinary conditions inside a contract. Let's now talk about the rules regarding the enforcement of contingent contracts. Section 32 to 36 explains exactly when contingent contract become enforceable. The first one is if event happens. So when a contract depends on the happening of the event, it becomes enforceable only when the event actually happens. For example, a promise to pay B if ship arrives, or the insurance claims after fire. Therefore, if there is fire, you will get the claim from the insurance. The next is when the contract depends on the non-happening, right? So it becomes enforceable when it becomes uncertain that the event will not happen. For example, A promised to pay B if ship does not return, when the event becomes impossible. So once it sinks or war is declared, contract becomes enforceable. The third one is when contract depends on future conduct of the person, or if the event becomes impossible. So here the contract is considered as void. For example, ship sinks, law changes, person involved dies. These rules ensure that contracts depend on uncertain events and are fairly enforced. Let's look at the examples for the exams. A agrees to pay B if C returns from Delhi. So what is happening in this case? It is enforceable only if when C returns. So here we are talking about the happening of the event. Next is A promised to pay B if a certain ship arrives. If ship sinks, the contract is void. Right. Now let's move to the next important topic, that is quasi contracts. We say that quasi contracts are not the actual contracts. So they are not an actual contract but obligations imposed by law. Why? To avoid unjust enrichment. So basically when we say that they are not the actual contract, this means that there was no offer, there was no acceptance and there was no agreement. Yet the law creates a contractual obligation. Why? To prevent the unjust enrichment, which means one person should not benefit unfairly at the cost of the another. So these obligations are imposed by the law and not by the choice. They are very common in business, consumer transactions, banking and daily life. Looking at the features of quasi contract, the first one is when there is no offer or no acceptance. This is what we understood, that it is actually not an actual contract. Therefore, there was no offer, there was no acceptance and there was no agreement. Yet we say that there is no mutual agreement as well, or no mutual consent, where the parties do not enter into any agreement voluntarily. That is why we say that it is enforced by law. So it is created by law. The law only treats the situation as if a contract exists. Then we say that it is actually designed to prevent the unfair advantage. Therefore, it is actually based on the equity and justice, where nobody should benefit unfairly. For example, paying money by mistake, finder of a lost goods, necessary goods supplied to a minor. These are all extremely scoring areas in the exams, right? Now let's understand what are the different types of quasi contracts. We say that quasi contract fall under section 68 to 72 of the Indian Contract Act. So let's start with section 68, which is supply of necessaries. If necessaries are supplied to a minor or someone incapable of contracting, the supplier can actually claim the reimbursement from the minor's property. For example, food, clothing, medical help provided to a minor. So this happens in case of legal guardians. So a legal guardian must reimburse those expenses that he is providing to the minor, right? Next is section 69. Here we say that it is person paying another's liabilities, or we also say it as payment by an entrusted person. A person who pays money on your behalf when you should have paid it can recover the amount. For example, tenant pays landlord's unpaid property tax to avoid the seizure, right? So this is wherein the another person is paying somebody's liability. This is section 69. Next is section 70, non-gratuitous act. If someone does something for another expecting payment and the other person benefits, then compensation must be paid. For example, a carpenter repairs the wrong house, so owner must compensate to the carpenter. Or maybe a plumber mistakenly repairs the wrong flat, then the owner must accept the benefit. Coming on to section 71, which is finder of goods. The finder must take care of the goods but also has certain rights such as lien for expenses. So the finder must return the goods but has a lien for those expenses, the amount which he had spent on for keeping the goods till the time they were returned. And finally, we say money paid by mistake or coercion, that comes under section 72. If money is paid by mistake or goods are delivered to the wrong person, they must be returned back. Example, bank transfers money to the wrong account. So they can claim and it should be returned back. These 5 categories form the basis of quasi-contract and are very important for short notes specifically. Some examples of quasi-contracts include paying electricity bills mistakenly, returning lost wallet, suppliers delivering goods to the wrong shop. They all come under the examples of quasi-contract. Now we begin the next major topic, that is contract of indemnity. Section 124 defines indemnity as a contract in which one party promises to save the other from loss caused by the conduct of the promise or of any other person. So, a contract in which one party promises to save the other from the loss caused by the conduct of promisor or the conduct of another person. In simple words, A promises to protect B from loss. Loss of what? It could be fire insurance, it could be marine insurance, employee fidelity insurance, business risk insurance. So here the indemnifier takes the responsibility to compensate the indemnified party for specific losses. Indemnity contracts are extremely important in business transactions. Why? Because they help manage and transfer the risk. Now, for example, somebody's business is such which has maximum risk of fire. So what do is they go for fire insurance. So here the indemnity term that we are using, so we say that one is the indemnifier, the one who promises to pay, the promisor, and the other party is called as indemnified, that is the one who actually has taken up the insurance or may have a risk for a loss or maybe for fire, right? So here there is a conduct of a promisor and a conduct of another person to save from the loss, right? Section 125 explains the rights of the indemnity holders, and that is the person protected from the loss. So if B is indemnified by A, So here B gets the following rights. First is recover all damages. The first right is to recover from all damages. So any damages B is legally forced to pay can be recovered from A, indemnifier. Next is right to recover all the costs. Legal expenses, court fees, lawyers' fees, if spent prudently and in good faith, then it must be reimbursed. The third one is right to recover all sums paid under the terms of compromise. So if B settles a legal claim in good faith, then A must reimburse all the amounts. Let's take an example here. A shipping company has indemnity insurance. So if goods are damaged in transit and compensation is paid to the buyer, the insurer must reimburse the shipping company, and this shows how indemnity protects the businesses from heavy financial losses. Now we move to the contract of guarantee, section 126. This section 126 defines guarantee as a contract to perform the promise or discharge the liability of a third person in case of his default. Right? So a guarantee involves three parties. One is the creditor to whom the guarantee is given. The other one is the principal debtor, person who takes the loan or liability. And the third one is the surety, the person who gives the guarantee. Let's understand it with an example. Father guaranteeing a son's education loan. Right? In this case, the creditor is the bank. The principal debtor is the son, for whose education's loan is taken, and the surety is given by the father. Similarly, a friend guaranteeing your business loan or a director guaranteeing a company's bank loan. So in a guarantee, the surety's liability is secondary, meaning he pays only if the principal debtor fails to pay. For example, you are starting up your own business. You go to the bank to ask for a loan, and the bank says that you need to get a surety for it, that you will be able to pay back your loan. So one person here becomes the guarantor. So the principal debtor is nobody but you who is starting the business. The creditor is the bank who is giving you the loan, and then your friend, for example, gives the guarantee or the surety, so he becomes the guarantor. So these are the three parties involved into it. Your friend will have to pay the amount if you fail to pay the bank loan. This is exactly the liability that happens on the guarantor. There are different types of guarantees. Guarantees can be of various types depending on the nature of the responsibility. The first one is a specific guarantee. It covers a single transaction. For example, guarantee for one loan or one purchase only. Next is a continuing guarantee. It covers a series of transactions. For example, guarantee given to a supplier for repeated credit purchases. Next is fidelity guarantee, which means that when the guarantee against employee dishonesty is taken, it is very commonly used in the companies. And then there are financial guarantee, like bank promises to pay if customer defaults. It is again widely used in business tenders and government contracts. So these types are frequently asked in the theory exam as well as in the practical case studies. What are the rights of the surety or the guarantor? So let's now discuss them and understand. A surety gives the financial assurance. So the law grants strong protection against or strong protection for the surety. The first right that the surety has is rights against the principal debtor. Right of indemnity or the surety can recover from the debtor everything he had paid to the creditor. For example, when father pays the son's defaulted loan, father can recover the amount from the son. Or when your friend has to pay the loan that you could not pay, then your friend has a right to recover that amount from you. Next is rights against the creditor. So here we are talking about right to securities. The surety is entitled to every security the creditor holds. So if the creditor loses the security, the surety's liability reduces. And the third one is rights against the co-sureties, which is right to the contribution. When multiple surety exist, all the contributors are equal unless the contract states otherwise. For example, A, B, C are co-suretors for rupees 90,000. So each contribute rupees 30,000 to it. These rights ensure that the sureties are treated fairly and are not exploited financially. Let's now move to the fifth part of the unit, which is bailment, lien and pledge. Starting with understanding the meaning of bailment, section 128 defines that the delivery of goods by one person to another for a specific purpose under a contract that the goods shall be returned or disposed of as directed. Here we see that there is a bailer, is a person who is delivering the goods or the owner of the goods, and the next one is the bailee, is the person who receives the goods or the custodian of the goods. For example, giving clothes to a dry cleaner. Most common example. Giving a vehicle for service. Delivering goods for the transportation. Handing over jewelry to a goldsmith for polishing. Or renting a locker for personal items. So in all these cases, the ownership remains with the bailer. Only possession gets the transfer. What are the various duties of a bailer? Under the Contract Act, the bailer has duties like the first one is disclose of faults. If the goods have any defect, the bailer must inform the bailee. For example, telling the mechanic that you break the system or the brake system of the car is faulty. Then is pay necessary expenses. So if the bailment is not for reward, that is for anything that is to be covered, the bailer must cover the necessary expenses that had held in case of making it right. The next one is duty to indemnify the bailee. The bailer must compensate the bailee for losses caused by the hidden defects in case the defects were not mentioned or disclosed earlier. These duties ensure safety and fairness in the bailment transactions. Similar to the duties of bailer, there are some duties for a bailee as well. First one is duty to take the reasonable care of the goods. The bailee must take the same care as a person of the ordinary prudence. For example, a mechanic must keep your car safely. Next is duty not to mix the goods. If goods are mixed without consent, then there is a problem. So if separable, then bailee bears the cost, and if they get mixed and they are inseparable, then bailee compensate for the loss. The next one is to return the goods. Once the purpose of the bailment is complete, the bailee must return the goods immediately. And the last one is to return the increase or the profit. If goods generate any profit, it must be returned. For example, if you give a cow for safekeeping and it gives birth, the calf must be returned. These duties again safeguards the bailer's property. Now let's understand the meaning of lien or right to retain goods. This means that the right to retain the possession of goods until the dues are paid. There are two major types of liens. One is a particular lien and the second one is a general lien. Particular lien is when there is a right to retain the good for charges related to that specific good. For example, a tailor can retain the clothes until the stitching charges are paid to the tailor. And then there are general lien, which is rights to retain the goods for any general balance of account, not only for specific good. So only certain professionals have this right to keep the general lien. For example, bankers, factors, wharfingers, attorneys, policy brokers, or jewelers. Right? Jewelers keep ring until the payment is made. Bank retain the document until the dues are cleared. These rights ensure the service providers are not left unpaid. Coming on to pledge, section 172. Let's understand that what it is. The bailment of goods as security for payment of a debt or performance of a promise. So when you deliver the goods as security for the repayment. Now here there are two people involved, pawner or the pledger, and then there is a pawnee or the receiver. Right? For example, gold loan. In case of gold loan, what happens that you put your gold into the bank and you take the loan against it. At the time of payback, you pay the amount and your gold is returned. So pledging jewelry to the bank, delivering goods as security for a business loan, pledging shares or warehouse receipts, they are all common examples that come under pledge. The main purpose of a pledge is security for repayment. There are certain rights of a pawnee. The pawnee who receives the pledged goods has strong rights under the law. The first is right to retain the goods. He can retain the goods until the payment is made with interest. Right? So the pawnee can retain goods until the debt along with interest is paid. Next is right to receive the extraordinary expenses. So recover interest plus expensive. If a pawnee spends money for preservation or to upkeep the product, he can then further recover it. Example, bank paying for locker damage repairs. And finally, sell goods with notice. If the pawner defaults, the pawnee can sell the goods after reasonable notice. Example, if you default on a gold loan, the bank can auction the jewelry. So these pledge protects lenders by also ensuring the borrowers are treated fairly. Now we move to the final major section of Unit 2, that is contracts of agency. Section 182 defines agency as a relationship where one person called the agent is authorized to act on behalf of another person called the principal. Why? To create legal relationship with the third parties. Meaning whatever the agent does within their authority legally binds the principal. We can take various examples here. A broker selling his house, a salesperson purchasing goods for a company, a lawyer representing a client, a post office delivering mail, or maybe a stockbroker buying shares for an investor. So therefore we understand that agencies everywhere in business, companies operate through these agents. Now we understand that agencies can be created in several ways even without a written contract. So what are those ways? First is agencies by express agreement. It can be created by spoken words or in writing. For example, written agreement between a company and the sales representative. Next is agency by implied agreement, where it is created through the conduct or the circumstances. For example, a shop assist automatically becomes the agent for the shop owner, right? Then we say that an agency can be created by estoppel, which means that when the principal's behavior make a third party believe another person is an agent. So here the principal is bound. For example, allowing someone to regularly act on your behalf without any objection. Next, the agency can be created by necessity. It arises in emergency situations. For example, a carrier selling perishable goods to prevent the loss. Next is an agency can be created by ratification. When the principal approves an unauthorized act later. For example, an employee signs contract without authority and then boss later approves it. So it becomes a valid agency. These different forms make agency very flexible in business situations. Now let's understand that these agents, they carry legal responsibility because they act on behalf of the principal. So there are certain duties of the agents. Duty to follow principles, instruction is the first and foremost duty of an agent. For example, if told to sell a car at minimum rupees 3 lakh, the agent cannot sell the car at any price below 3 lakh. The next duty is to act with reasonable skill and care. The agent must act like a prudent businessman. Duty to render the accounts. Agent must maintain proper records and provide them when asked. Duty to maintain the secrecy. They should not leak any of the information of the principal. Then the duty to not to delegate the authority, wherein agents cannot appoint sub-agents until or unless allowed by the custom or the contract. So these duties protect the principal's interests. Likewise, there are some rights of the agents as well. Right to remuneration. Agents are entitled to salary or the commission agreed upon for the work that they are doing for the principal. Right to lien. Agent may retain goods or documents until payment is made. And right to indemnification, which means the principal must compensate the agent for the losses suffered while performing the lawful act. There are other rights also, like rights to reimbursement, rights to indemnity, or right to retainer. These rights ensure fair and smooth functioning of the agency relationship, the relationship between the agent and the principal. The principal also has some responsibilities towards the agent. The first duty is to pay the remuneration. Whether commission or salary, payment must be made as agreed to the agent. Duty to indemnify the agent. If the agent faces loss while performing the lawful act, the principal must compensate for that loss. And duty to not prevent agent's work. The principal must cooperate and not obstruct the agent's functioning. A healthy principal-agent relationship depends on the mutual trust and the responsibility that they share with each other. Now, agencies may come to an end in several ways. According to section 201 to 2210, termination can occur first by agreement, where both principal and agent mutually decide to end the relationship. Then by revocation, where principal withdraws the authority of the agent. By renunciation, agent decides to resign. By completion of the business, once the task is done, for example, the house is sold, the agency ends. On the death or the insanity, death or mental illness of the principal or agent ends the agency automatically. On insolvency of the principal, if the principal declares bankruptcy, agency ends. So understanding the termination is important because many case studies and exams are based on this topic. Let's look at the difference between the bailment and pledge. Before we move to the final closing slide, let us revise the key differences between the bailment and pledge. In case of bailment, we say that the goods given for the temporary purpose, but in case of pledge, the goods given are as security. Bailment में bailee cannot sell the goods, but in case of pledge, the pawnee can sell in case of default. Under bailment, the purpose varies, that for which purpose the bailment has been done. In case of pledge, the purpose is only to loan the security. There are no rights to sue for debt in case of bailment, but pawnee can sue for the debts. Bailee has limited rights, whereas here in case of pledge, the pawnee can sell the goods. Let's take an example of a bailment: car to the workshop for a repair, and pledge is, let's say, gold loan. There are some examples which I have written here. Giving bike for service is the example of bailment, but gold loan is the example of pledge. Delivering of goods to transporter is bailment, but agent selling the car is an example of agency. Now let's come on to the very important slide of the entire session, where we talk about the important past year questions. Define contingent contract, explain rules regarding the enforcement. What are quasi contracts? Explain their types. Distinguish between indemnity and guarantee. Explain bailment and pledge with rights and their duties. And finally, describe the creation and termination of agency. Thank you so much for learning with BBA Simplified by Dr. Vinky Sharma. In the next video, we'll be talking about Unit 3, that is Sales of Goods Act. Do like, share and subscribe for more marathon classes. Thank you so much for watching.